Hi friends, I'm Naavi of Naavi Academy. Today, the 27th of October 2024, let us spend a few minutes on discussing the concept of data fiduciary under DPDPA. A data fiduciary under the Digital Personal Data Protection Act of India is a role which looks similar to the data controller under GDPR. However, it is having several nuances which make it different from the concept of data controller. The very fact that this role is called a fiduciary means that this entity will have a responsibility to take a care for the privacy protection of the data principal. So therefore, a fiduciary is expected to have much more responsibility than a controller. A controller can very well follow instructions from the data subject in the form of a well-drafted consent form, which has got a notice and then, of course, list of things which are permitted for the controller to do. In the case of a data fiduciary, though the basic instructions are passed on by the data principal to the data fiduciary in the form of a informed consent, the expectation of a fiduciary who is like a trustee is to take an independent view of what is good for the person on whose behalf he is taking a decision. Therefore, if the permissions granted are unclear in a particular context, for example, the data fiduciary has to take a view which is more favorable to the data principal. So this is the most essential aspect. And in fact, Indian law recognizes duties for the data principal. You can say data fiduciary concept imposes duties on the entity which is processing the personal data and determining the purpose and means of processing. Now, when we say a data fiduciary is an entity which determines the purpose and means of processing of personal data, there arises some instances where more than one organization is involved in determining the purpose and the means. Most probably, one organization determines the purpose for which a personal data is collected and processed, but it is processed by another organization, and that organization determines how it is being processed for a given purpose. Therefore, both the organizations have shared responsibilities as a data fiduciary, and they are referred to by us as joint data fiduciaries. Now, in case one organization determines both the purpose and the means and engages the services of another organization under a contract just to process it under specific instructions of the first organization, we call the second organization as the data processor. So therefore, we have a data fiduciary and a data processor. In certain cases, there are data fiduciary 1 and data fiduciary 2 and then the data processor. Now, sometimes when we look at these laws, whether it is GDPR or DPDPA, we ask a question, is the entity a data fiduciary? This becomes relevant also from the point of view of a significant data fiduciary who is a special category of data fiduciary, which the government may determine based on the, let us say, volume of data processed or the sensitivity of data processed and so on. So in such cases, a question will come, is this tag of data fiduciary or the significant data fiduciary is associated with the entity as a whole, or there are any other ways of looking at associating this role with what is going on in a company. DGPSI, which is the corporate mantra for compliance of DPDPA in India, also provides certain guidance in interpreting the law. That is why we say DGPSI is a jurisprudence in data protection. What DGPSI suggests is, don't look at an organization as a whole and categorize it as a data fiduciary or a data processor. Look at the specific process where a set of personal data is being processed. When we say process, process includes collection, it includes storage, it includes manipulation, and includes even deletion. Okay, so whatever is the way personal data is processed, and particularly when that personal data happens to be personal data for which DPDPA is applicable, that is the data which is collected from India and it is processed either in India or outside, but for providing services to the data principals in India. So that personal data, when it is processed, there is one process in which this processing happens. Now, an organization which is into data related activities has multiple processes and multiple services. In certain processes, it acts as a data fiduciary because it collects the data for its own purpose and processes it as per its own discretion. So there it is a data fiduciary. So the process relates to the role as a data fiduciary. If there is another process in which collection for the purpose is done by this organization, but the processing, the means of which is determined by another organization, is outsourced, then the role of this organization in this process is that of a joint fiduciary with some other XYZ. In cases where the first organization determines both the purpose and means and still outsources the data for processing to some outsider, then this outsider organization will become the data processor, and this company is the data fiduciary with reference to that particular process. This is clear. Now, this same organization may also have a service in which it processes personal data on behalf of another organization, which could be the data fiduciary in that context, and the data processed by this organization on behalf of the other organization could be an activity similar to data processor. So therefore, we say an entity can be a data fiduciary in certain processes and a data processor in certain processes, and the organization as a whole is a combination of multiple processes and therefore is a hybrid entity where in certain instances it is a data fiduciary, certain instances it is a data processor. It can also be in certain instances significant data fiduciary. Okay, so the role of data fiduciary is not unique to the organization as a whole. Now, this aspect has some relationship to the way we define roles of organizations under Information Technology Act as intermediaries and others who handle the data for their own purpose. See, if an organization is handling personal data, that was sensitive personal data, then IDA 2000 under section 43 capital A wants it to follow certain reasonable security practices. In case there is a failure, that organization is liable for payment of compensation to the affected persons. Now, there are a class of data handlers under Information Technology Act which are called intermediaries. The intermediaries don't process data for themselves. They handle data for passing it on from one source to another. And one example could be an ISP, okay, which is a pure, you can say, intermediary, which receives the data from one end, passes it on to the other end. There are other organizations or say activities which are, you can say, quasi-intermediary status, like the hosting services, e-commerce services, etc. The Information Technology Act sometimes identifies them also as intermediaries. So an organization under ITA 2000 can be an intermediary or a non-intermediary data handler. Now, the question which we are also checking up is whether this status of an intermediary is similar to the status of a data processor under the DPDPA. Okay. Now, if the data processor is handling a data, he is, of course, handling the data in certain capacities. There are certain capacities in which he is only a conduit for data, in which case he is a data intermediary. And since giving a passage to the data is also processing, we can say that all intermediaries are also in some way doing some kind of a data process. Now, whether a data fiduciary can be an intermediary is another question which was raised recently. Now, if a data fiduciary is a company or an organization which processes the data for itself, for its own purpose, then obviously it is a data consumer and therefore it cannot be a data intermediary. However, if there are certain processes within the operations of this company in which this company acts as a processor instead of a fiduciary, there may be a possibility that in that process, this organization can be an intermediary under ITA 2000 also. However, we must remember that the definition of intermediary in ITA 2000 is very clear that if an organization is actually manipulating a data, then it will not qualify to be called an intermediary. If a data processor is therefore not having a process of transmission of data from one end to another end, which is a pure intermediary transaction, but is processing it for certain purposes as defined by a data fiduciary, then that data processor cannot be called an intermediary because he is also a consumer of data. That any organization which consumes the data for its own activity is not an intermediary. So this interaction of roles between the two laws needs to be understood properly, because when a data breach occurs, okay, now Information Technology Act states that under section 43 capital A, you are liable if you are having sensitive personal information being processed, which section is going to be replaced by DPDPA later on. But even after that, there will be a section 43 associated with section 66, where this data breach can create a liability. Now, apart from that, if there is an organization which is contractually processing the data for another organization, which happens to be a relationship between data fiduciary and data processor, there is a section called 72 capital A, which says that if one organization has passed on personal data to another organization under a contract, and that second organization fails to follow the contractual demands and thereby causes a compromise of the personal data, which is a breach, then that second organization will become liable to the first organization for contractual breach to the extent of 25 lakhs kind of a thing. So therefore, a data processor processing personal data, whether it is sensitive or not, on behalf of a data fiduciary, compromises the personal data not permitted under the contract, is liable under Information Technology Act. Whereas DPDPA itself does not directly impose any penalty of this 250 crores, etc., on the data processor, but leaves it to the contractual binding between the data fiduciary and data processor, where an indemnity clause would be there. So I would like the viewers to reflect upon this role of an organization under DPDPA and ITA 2000 and understand the differences. Summarizing what I just said, I say that data processing under DPDPA should be looked at as a process level activity, and for each process you have to determine whether the role of an organization is that of a data fiduciary or data processor. At the same time, whether a data fiduciary or a data processor is an intermediary under Information Technology Act or not, and in the case of a data breach, whether he will be capable of using the safe harbor protection under section 79 or not, depends upon whether this organization is only an intermediary or more than an intermediary. Since data fiduciary by definition cannot be only an intermediary passing on the message from one end to the other end, it is essential to say that all data fiduciaries are those who may not be as an entity intermediaries, but there may be a process within that data fiduciary's activity where it is a data processor, not a data fiduciary, where that process may not involve any handling of the data on its own, and it is only a conduit of data from one end to another end, and therefore it can be an intermediary in a particular process. ITA 2000 does recognize that the intermediary status is more related to a given message and not to the entire organization. So this process level determination of the role, which DGPSI has been strongly advocating, is validated by the way the Intermediary in Information Technology Act is defined with reference to the message. And a similar outlook is taken in the DPDPA ecosystem, where the role is defined with reference to a process involving personal data and not the entire entity. So this is a very important concept which needs to be understood, and probably when we come to the significant data fiduciary kind of determination, there also certain processes may be significant data fiduciary processes, certain processes are only data fiduciary processes, and an organization may still have some processes in which it is neither the data fiduciary nor the significant data fiduciary, but it's only a processor. And ultimately, an organization is a hybrid entity of activities in which it is a data processor, it is a data fiduciary, it is a significant data fiduciary. Okay, now whether the role of a consent manager can be combined here, at present I'll say no, because consent manager cannot have any conflict of interest with the data fiduciary. So you cannot combine the role of a consent manager into these three roles. So an organization can either be a fiduciary, significant data fiduciary, and a data processor, and it cannot simultaneously be a consent manager. So this is the summary of today's discussion. If you have any comments, you please let me know. I will be quite happy to respond to your specific queries. Thank you.